Hypocrisy.
Hey, what's up, guys? Welcome to Hate-Splaining the Interwebs. I am your hate host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, the land of hate, the land of 10,000 hates. How are you guys doing tonight? How are you guys doing tonight? Thank you, Corono, for posting that wonderful comment for me to hide user from channel. Oh my goodness. So, last night, of course, we started this document. Tonight, we will jump back into it in a little bit. I'm going to let people filter in, right? Because viewership is like way lower than it will be at the peak time. So we're going to let some people pile in before we get into the document. I am thirsty. Man, I had a day today. I don't know if you guys know this, but I drank a little bit of moonshine last night. For those of you who said more moonshine, I can't. It's dead, Jim. It's dead. So that's that. And when I woke up this morning, man, I felt it. I've had worse hangovers than whatever this was, but it was not pleasant. I felt just drained all day. So I did not have any short videos today, though there are several very interesting topics which I do intend to cover hopefully tomorrow on those. I was making a brisket though, and let me tell you about that brisket. So last night, all through the show, everything's fine. I go upstairs. I don't know when we ended, somewhere around 3:30 or whatever. 3:30 in the morning. I go up to check on the brisket. It's going great. It's at a nice temperature. Things are going just fine. And then I sit down in my chair and I'm like, okay, I'm going to take a rest for a little bit here. Take a rest, I'll wake up. And the plan was to wake up, check the brisket, and then come downstairs and stream the Chauvin trial. We saw how that worked out. So I woke up at about 7:45 in the morning, which is right around the time I wanted to wake up. I woke up and I went, oh, okay. So I went to check the brisket, and it was at this point already snowing, and the wind or something had blown out my smoke, the firebox of my smoker had been blown out by the wind. And I go up, and I don't know how long it had been out. Sometime in the last 3 hours it had gone out. So I go up and I touch the brisket, and it is cold. 'Cause it's cold enough to have snow, and the snow was sticking. So the brisket is cold. But at least the brisket had made it to temperature. So now it's just kind of like reheating it. So I turn the smoker back on 225 degrees to get it warmed up. I'm like, I'm going to go lay down for a bit. I'll get it back up to temp. I'll wrap it up and throw it in the oven. It'll be just fine. Nope. I got back up around 11 a.m. and the smoker had gone out again. So that was great. I did not anticipate a snowstorm, a windy snowstorm to come through, but I will tell you, the brisket was still delicious. It was still delicious. It was good. The pictures of it are up on Locals. It was the flat of the brisket was a little drier than I would like, but it was still good. I'll just make one when it's not going to blow the firebox out. That would be great. Stupid Minnesota. Minnesota is the worst hell on earth. It is the worst hell on earth. And I hate it. And a nuclear winter wouldn't be any worse than a regular winter. So you say, of course, it gets cold. It's been 60 degrees, though. It's been 60 degrees. And the thing ran for, I don't know, 8-10 hours just fine when it was above 30. But anyway, it was really good. I just ate some. Had my man Q over from Out of the Darkness. He had some brisket with me too. That was great. We had brisket and whiskey. Lunch. Afternoon lunch. I don't know, whatever it was. But here's the most important thing that happened today. Here's the most important thing that happened today. Okay. Q told me about a news story in Minnesota, and this had me a mixture of elated, excited, titillated, and afraid, all at the same time. All right? All of these things combined in this one news story. My emotions are on a roller coaster right now, still from it. I'm literally shaking. You've heard me talk about donuts. You know what I believe about donuts. You know my donut ethos. Texas has the best donuts that exist, and they're all made by Vietnamese people. All of them. Without fail. All right? There was a news story. This is a legit news story. In Minnesota, a Vietnamese person has moved from Texas to Minnesota and opened a donut shop. Yes! Yes! It was on the news. I have long said, you guys don't understand Minnesota. I promise you, you can't This is a foreign land pretending to be America. It is the worst state. I see you guys. Oh, New Jersey, Rhode Island, Missouri. Stop it. You don't understand Minnesota because you don't understand Minnesotans. Okay? Anybody who's lived in like Texas or California knows what a real donut is. Okay? You grab, like, it's not an event. It's not a big like thing, a presentation. I went to Austin and they had this Gordo's donut shop, and it's like an effing cake covered in all this bullshit. It was a waste of time, and the donut wasn't even good. No, a good donut. What about Tim Horton Corono? You want to get unmodded? Do you want to get unmodded? All right. A good donut that happens in Texas, California, wherever. You can find them scattered across the country. You pick it up. It's not Krispy Kreme. Stop it. Stop. Oh God, Big Donut is ruining everything. You pick it up. It's basic. There's like 12 of them. It doesn't matter. It costs like $5 for 12 donuts. You don't care. You buy like 30 of them because who cares? They're free. They're almost free. And you pick it up and you eat it. And it's just so good that you don't like, it's not like a change your life thing though. It's a staple. It's like rice. Okay? It's like rice in some country where they don't have other food. You're just like, oh, just donuts. That's just breakfast and your whole day. Okay? This is what a donut is. And I'm telling you, People from the South know what I'm talking about. Shipley's, if you're in Texas, is like your good baseline donut that I'm talking about, okay? And if your donut is not like Shipley's, but better, I don't want to talk to you. I don't even care. Like, don't give me your stupid cake donut. You ever bring a cake donut in my house, I'm calling the cops. Get out. This is important. It's not like an event. It's not a change your life thing. It's just subtle perfection over and over every day, every donut that you eat. And they're gooey, they melt in your mouth, and they're great. And again, if you're not from Minnesota, you won't understand how bad this state is. If you try and explain donuts to people in Minnesota, they're like, huh? No, you get donuts at the grocery store. You're like, stop it. Be gone, Satan. Get thee behind me. No, you do not get donuts at a grocery store unless you've been in a desert for 8 weeks finding Jesus, and that's the only sustenance on the planet. No, you do not. And so Minnesotans don't understand the Southern donut, because the Southern donut goes like this. This is, when I go to Texas, let me explain this to you. This is every day that I'm in Texas. Every day I wake up in Dunkin' Donuts. No, not Dunkin'. Those are all cake donuts, and all of them should die. Cake eaters, didn't you watch Mighty Ducks? This is blasphemy. I can't believe this. Every day I'm in Texas, it goes like this. I wake up in the morning. I either get in a car if I have to. You typically don't have to, because there's usually one within walking distance. And you go to the donut shop, or I go to the donut shop. Every morning, I buy me 2 kolaches, Lady Rackets 1 kolache, and then a couple extra kolaches for the kids. And then I buy, at minimum, a dozen donuts, usually 18, every single day. And then you buy milk or chocolate milk or juice or whatever drink you need. And you can feed a family of 7 like this for $20. You can feed them all breakfast and have plenty left over. So good. So good. And I will do this every day. Now, what I try to do is I try to go to a different donut shop every day that I'm in Texas. All right? No, I don't like coffee. I don't. I know everybody likes coffee. I don't like it. Don't like the taste. Don't like the flavor. There's probably a childhood trauma. I don't know. It's not my thing. Not my thing. But no, I don't like coffee. So anyway. What Minnesotans don't understand is that a donut and a kolache, that's breakfast. That's the breakfast of kings. That's how you become strong. That's how you become a person. And that's why Minnesota has no people in it. And if you don't know what a kolache is, it's a sweet roll wrapped around some sort of sausage, and sometimes you add jalapeno or cheese or some other filling in there. They're magic. Don't hit me with that fruit kolache bullshit. That's garbage. No, thank you. Take your fruits and go to San Francisco, okay? Nobody wants them here. But that's a Texas breakfast every single morning. And now they have one in Minnesota. In Minnesota. And you have to understand, if your donuts aren't being made by Vietnamese people, it's not good. I don't know what it is. I don't know what special communism powers that were deployed to make Vietnamese people the king of donuts. It's probably racist to suggest this, but it's truth. It's just truth. 100% of Vietnamese people are responsible for 100% of good donuts. I don't know why. It's like a racial modifier in Skyrim or something like that. Like, makes good donuts. That's the ability. I don't know what it is. But I shed a tear. I shed a tear when Q shows me this not the commercial, the news story about the Vietnamese immigrant from Texas to Minnesota. They're probably born in the States. When I say immigrant, I mean from Texas to Minnesota, because Minnesota is a foreign land. You have to understand this. And so when I saw it, I'm like, oh, thank you, God. You finally brought the chosen people to Minnesota to make donuts. Oh. Oh, my God. You'd think, by the way, that Minnesota would be good at donuts. It's full of fat people who like pastries, and they're all pasty white. A bunch of Germans, Norwegians, like Belgians or whatever. A bunch of people who invented waffles and bread all live here, and they don't know how to make donuts. It's the weirdest thing. They can make pies. Like there's Dutch people here too. What a waste of an entire region of Europe they don't appreciate good donuts. I don't get it. I don't get it. So anyway, Q is picking me up at 6 in the morning tomorrow. Q is picking me up at 6 in the morning tomorrow, and we are making the 2-hour drive to the Twin Cities. We're going to risk the wrath of Black Lives Matter. We're going to risk the wrath of Antifa, and we are going to buy donuts tomorrow morning. I'm so excited. Oh, there's still Twitch. Guys, do I make good decisions? No. Of course there's still Twitch. This is not a short stream. All of this is happening. Live streaming is a possibility. So, Sneed, I don't know what the place is called, actually. I don't know. Q has all the information. But yeah. We're going to have a good time. I'm with Q. I'll be fine unless we get pulled over. I still remember Philando. Oh, by the way, Q and I were talking about that today. So, Justine DeMond's family got $20 million, right? And then we got George Floyd's family gets $27 million. Does anybody even know what Philando Castile got? I'm going to look at Philando Castile settlement. Oh, man. Philando. My man Philando. Probably a more egregious police killing than Chauvin, and possibly more egregious than Mohammed Noor. 3.8 million. 3.8 million. It's a crime. It was one of the more egregious police killings that has happened. Not only does the cop walk, Philando's family gets 3.8 million. But Floyd, Philando, let's remind the chat here. Philando's Philando's criminal record was literally traffic stops. Like literally traffic stops. That's it. I don't know if there was a minor drug charge somewhere in his past, but it was an embarrassingly mundane criminal record. Floyd's is armed robbery, whatever. And Philando, if you go watch that video, man, he gets shot so fast. So fast. Blam, 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 blam. Whoa. Whoa. He gets put down by the officer. And, whew. There wasn't like a resisting arrest. There wasn't a weapon. Didn't he reach for something? Yeah, his wallet for his license and registration. Man, it was, that was a bad one. But again, if you like go watch that video, the amount of time, it's that shot is lightning fast. Again, I don't know what that cop, I don't know what his issue was. I think he was scared. for sure. He looked scared. He acted scared by shooting someone. But he was scared when he pulled that car over. He was scared the entire time. He was on edge. He should not have been pulling people over that day. I got to pre-hydrate because I forget to hydrate later. When will yesterday's live stream be posted? I don't see it. It's up. It's up on the archive channel. The Ricada Law live channel. It's up. It's public. I'm looking at it right now. So it's there. Christian Delgado. If you are not subscribed to the archive channel, you may not see it, but it's there. So, and if you're not subscribed to the archive channel, go there. Also, follow me on Locals. You don't have to pay anything to follow me on Locals. You may choose to participate in the payment side of Locals after you get a look at it. That's up to you. It should be fully live, I think this week. Okay. Let's do super chats, and then we're going to get back into, here's the document. Here's where we left off. Super chats. I'll recap where we are in this document, how it might relate to Vic. We're going to have some discussion on how it might relate to Vic in more depth after we're done reading it, but just why this is being covered. And I'll give the same sort of spiel as yesterday, but shorter. Okay, so here we go. We've got that nerd Derek says, good news. Got my kidney stone taken care of. Thanks to everyone who donated. Could use a bit more help though. It's still a decent financial strain. Might I get a scrap of shilling for my GoFundMe? I don't know where it is, but sure. If you want to like put in chat where people can find your GoFundMe, go ahead. Go ahead and do that. Bad Vibe says, if Minnesota is the land of lakes and hate, where's the lake of fire? Oh, that's simple. That's in Wyoming. Lost Bullet says, Mr. Y Voice, hey, Lil Nicky, are you a Michael Jackson fan? Because when you come to my house, you make me want to free my willy. Gross. I can't milady with the hat. Oh, he milady's for me. Beautiful. Felipe Movie says, who are you and what did you do with Nikki? Everybody here knows Nikki only wears t-shirts and looks like a gay lawyer, not like a cis lumberjack. Look, I'm trying to diversify my wardrobe a little bit. That's all. Kyra says, no truer words have been spoken. I just never heard it vocalized till now. Preach, Nick, preach. Hashtag Houstonian. Kyra, you know what I mean? By the way, check out Best Donuts. Best Donuts in Houston. Oh my God. And find yourself. I don't know if they have them in Houston. In Tyler at Donut Palace, they do Earl Campbell kolaches. They have Earl Campbell Hot Link kolaches. Oh my goodness. Oh, but find that Best Donuts, Kyra. Eat a donut or two for me, because God, I love them. Bad Vibe says, want to know what Nick considers a good donut? One that can easily hang off his nose. Yes. Yes. Mithrin Emrys says, you're forgetting some important things, Nick. It has to be a hole in the wall and only the cashier speaks English, kind of like good Mexican food. Yeah, I mean, you're getting it. You're getting it. That's why Krispy Kreme is not it. And trust me, Krispy Kreme is not it. Krispy Kreme is the Walmart of donuts. Bad Vibes. Bad Vibes says he doesn't like coffee but loves coffee cake. I don't like coffee cake, no. Generalissimo says, after that rant about anime, Muslims, the correct process for basting kitten brisket and repeatedly stating that murdering cucks is not technically murder as actual legal advice, I'm curious how you will up the ante. You haven't even seen me get started yet. This isn't even my final form. Stooge Muffin Stuffin says, I got the Akira 35th anniversary box set for my birthday yesterday. Hey, cool, man. Akira's a good flick. Drew S. I don't know. I don't know where Leander, Texas is. I'm not familiar. Okay. All right. So this is a case. This is a story all about how TCPA got flipped, turned upside down. This is a Texas second Court of Appeals case that came out on Thursday. They release. Oh, by the way, one last thing. Sorry, I'm on Odyssey also. If you hate YouTube and you want to watch things on Odyssey, I'm over on Odyssey. My videos, I guess, get mirrored over there. I don't know how they handle the live streams that I unlist yet, but I'm checking it out. They're still uploading old live streams there, but all my stuff is mirrored over on Odyssey. If you're an Odyssey user, you can check it out. People have been telling me to get on some alternative tech platform for people who hate YouTube, and there you go. It's on Odyssey. It's there. So you can go subscribe and check it out, and if you want to share videos from there, whatever you want to do, it's all up and running. All right. Okay, back to this. So this is a TCPA case, which is Vic Mignogna is who we're tangentially talking about here. This is a TCPA case that was decided by the Second Court of Appeals. It's the same court that will be deciding Vic's case. That decision could come out Thursday. It could come out any Thursday from now until forever. We don't know when it'll happen, have no idea. This case was briefed. The appeal was filed and it was briefed after Vic's case. So to point out that there is no order or predictability in this sort of thing. I wish I could tell you and give you a better timeline, but I just can't. They don't have one. So this was briefed and decided. It was briefed after Vic's case, decided before Vic's case. That being said, it's an interesting look at how the Second Court of Appeals is applying the TCPA. So what we can do with this information is we can look at it, take what we know about Vic's case, and try and draw some parallels and conclusions. What we cannot do with this is say that Vic's case will definitely be decided along the same lines. A lot of things go into an appeal. The pleadings that were used in the lower court, the evidence submitted and admitted to the lower court, that makes up the record for the appeal. And then further, how the briefs are written for the appeal, what the briefs are on the issues, what the trial court ruled. It matters because you've got a different procedural posture. And so there are differences here. So we can't say that because this one worked out in a way that would be great for Vic, that it means that Vic's case will go the same way. However, I do think there's a little reason to be at least a teeny optimistic from it. There's optimism in how the court is looking at the TCPA, and I really do think there's some grounds for it. I've been really, really hesitant to do any of this stuff because I'm not trying to get people's hopes up. I've not been a hype machine since the dismissal of the case, and I think that actually made a lot of people mad. I really do. I think a lot of people got frustrated and left when I was not rah-rahing the cause. But you know, that's how it goes. I did not want to set people up for disappointment because it's still a tough battle. The procedural posture of this case is different. In this case, the TCPA was rejected by the lower court. So when it goes up to the appeals court says, yes, we agree with the lower court. They don't have to overturn the decision. In Vic's case, the lower court granted the TCPA. And so when it's going up to the appeals court, they have the opposite. They have to overturn the lower court's decision. Whether or not they will, you know, that's up to them. But that's a very significant difference here that we have to point out. All right. Gerard Garvin, chup done, chupped up. Let me just be clear. That's not the appropriate expression. It is fuck done, chupped up. So there you go. Yeah, Frank the Tank. Oh, I get it. All right. So here we go. We are on page 31. So here's a brief background. If you weren't here yesterday, I'll keep this short. Watkins is a lady. Miller is also a lady. Miller said a bunch of shit about Watkins, and Watkins sued Miller for it. There you go. You're caught up. Miller filed her TCPA. The court rejected it. So now, here we are. Bad Vibe says, White Pillas Grifter. And Texas Red says, just sub via locals. The next time you are in Austin, come check out Round Rock Donut. They have the donut that most of the Asian donuts are trying to replicate and sausage made specifically for their kolaches. Maybe. We'll see. Have you been to Gordo's? By the way, if you haven't, don't. Not for donuts anyway. Go to Gordo's for some other reason. All right, we're picking up right here. This is in the court's examination of defamation. Again, if you didn't watch yesterday's video, I encourage you to watch all the way up to the point where I start screaming at the chat about anime. Because that is that'll catch you up here as well. Felipe Mouve says, Nick, now I get it. You're trying to look like you are super straight. I'm afraid that ship has sailed a long time ago for you, my friend. All right. Further, Miller claimed that Watkins had committed acts that are accusations of the crime of online impersonation. Though Miller later tried to assert that she had never filed a formal police report specifically accusing Watkins of a crime, she sent a police report to the school stating that she had told police that she believed that Watkins had been creating false Facebook profiles in order to spy and send messages to other individuals to slander Miller. In the report that Miller shared with the school, police stated that they had advised Miller of the law regarding online impersonation could possibly be a criminal charge if Watkins had been using information of another person to create profiles and using them with the intent to harm Miller. Miller made similar allegations to school officials and other parents. In essence, Miller published statements that Watkins had performed acts that potentially constituted a crime and then provided the school with a report from police that outlined the nature of the alleged criminal offense that might have been committed based on the acts Miller had accused Watkins of doing. Such an accusation is reasonably capable of defaming Watkins. So here we have someone saying that someone did a crime, did a criminal act, which should sound familiar to you because Vic was accused of several criminal acts. All right. With regard to the third element of defamation, there is prima facie proof that Miller acted with the requisite degree of fault. Now, this is a very interesting section. So the requisite degree of fault for defamation is negligence for normal people and actual malice for public figures. If you'll remember, Law Twitter made a huge beef about actual malice being basically impossible to prove without having some sort of admission from a party that they knew they were lying. They're like, well, how can you possibly assert it? Now, the counter argument to that was a case called Vanderlinden versus Kahn, in which there were two people, they were the only two people, and the question was basically to prove the knowledge of the falsity with a he said, she said was just to prove, have the person say that it was false. They're saying this, it was false. I was there. That's a prima facie showing of falsity and of knowledge of the falsity, because if there's only two people there who are party to the conversation, then the two people must know the truth, so they must have knowledge of what they're saying is false. If this sounds like it should be familiar to Vic and Monica's situation or Vic and Jamie Markey's situation, that's because it absolutely should. Vic and Jamie Markey and Vic and Monica are the only two people on each of those events who know what happened between them. So if Vic says, I didn't do that to either of them, then he didn't do that. And if he didn't do that, then you can't have defamation. That would be the thinking here. In a perfect world, that is the argument. Law Twitter swore that wasn't how you do it. Let's see what the court says here. Zed Tempest says, I grift for Vic since I can't use debit cards on GoFundMe. This goes to you, Nikki. Hashtag cancel culture. Hey, thank you. All right. The parties dispute what level of fault should gauge whether Miller acted with a requisite degree of fault. Miller contends that Watkins was a limited-purpose public figure. Thus, Watkins carried the burden to establish that Miller acted with actual malice. Watkins disputes her status as a limited-purpose public figure and argues that she was required to present proof only that Miller acted negligently. The trial court resolved the issue by finding that Watkins' status as a limited-purpose public figure presented a question of fact, and by stating that without finding whether Watkins was a public figure for a limited purpose, the admissible evidence submitted by Watkins was sufficient to overcome the motion to dismiss, even under the New York Times Company versus Sullivan heightened standard of proof. So, this is, by the way, what Chupp should have done in regards to this element, because Vic being a public figure is a fact question that was not resolved because they had a dispute over it, and you can't resolve it if there's a dispute and you don't have a trial. But Judge Chupp is stupid. I don't know how else to say it. He's bad. In this case, at least, he's bad at being a judge. There's evidence that he's bad at being a judge in other cases, but I don't know if that's true. I do know that in this case, Judge Chupp was wrong. He was terrible at it. He was bad. And I do not feel sorry for saying that. So with that said, 1 second here. So with that said, we still have to see what they decide on the public figure argument. And then the other thing, though, is they said that the trial court said there was enough evidence even at the heightened standard of actual malice. And that's really, really important. All right. We adopt a similar approach to that of the trial court and assume, without deciding, that the heightened burden of proof of actual malice applies to Watkins' defamation claim. We need not resolve the question of what burden applies because there's prima facie proof that Miller acted with actual malice. Okay, now let's see why. Because we assume that Watkins bore the burden of presenting prima facie proof that Miller acted with actual malice, we will be succinct in describing the mare's nest of how courts decide what level of fault on part of a defendant accused of defamation must be proven. The Texas Supreme Court described how Texas law has evolved on the issue in response to holdings from the United States Supreme Court as follows. We have revised the elements of the defamation cause of action in response to the United States Supreme Court's application of constitutional principles to defamation claims. Before Sullivan, the defamation plaintiff generally prevailed by proving the defendant published a statement that defamed her unless the defendant proved the truth of the statement. But the Supreme Court held in Sullivan that freedom of expression requires breathing space, and that if the plaintiff is a public official, she must prove the defendant had actual malice. The court later held the public figures and limited purpose public figures must also prove actual malice, and that states may set their own level of fault for private plaintiff. The court left the precise standard of fault to the states, and we have chosen a negligence standard for a private figure seeking defamation damages from a media defendant. The court now conditions a libel action by a private person upon a showing of negligence, as contrasted with a showing of willful or reckless disregard. In light of these holdings, to recover defamation in Texas, a plaintiff must prove the media defendant published a statement that defamed the plaintiff while either acting with actual malice if the plaintiff was a public official or public figure, or negligence if the plaintiff was a private individual, regarding the truth of the statement. So, same thing. Negligence, actual malice, those are the two standards. The plaintiff who bears the burden of proving actual malice falls into three classes: public officials, general purpose public figures, and public figures for a limited purpose. No one contends that Watkins should be characterized as a general purpose public figure, which requires a person to have achieved such pervasive fame or notoriety that they become public figures for all purposes and in all contexts. Instead, the dispute below was whether Watkins is a limited purpose public figure, where a party may hold public figure status for a limited range of issues surrounding a particular public controversy. Courts look to three factors in deciding whether a party should be characterized as a limited purpose public figure. This should all be review, but if you are rusty on this, it's nice. 1, the controversy at issue must be public, both in the sense that people are discussing it and that people other than the immediate participants in the controversy are likely to feel the impact of its resolution. The plaintiff must have more than a trivial or tangential role in the controversy, and the alleged defamation must be germane to the plaintiff's participation in the controversy. Also, as stated above, a public official may bear the burden of proving actual malice. Neither party addresses whether the fact that Watkins was a substitute teacher makes her a public official. So they didn't make that argument. They should have, but they didn't. We will not decide that question, but will observe that there's a nationwide split on the question of whether a public school teacher is a public official. So then they have the citations to the different appeals courts and how they've ruled in different jurisdictions. Finally, we sidestep the raft of issues required to decide whether Watkins is a limited purpose public figure or a public official by our holding that there is prima facie proof that Miller acted with actual malice. Okay, so they're going to skip the public figure argument and just say, nope, there's enough. So, now, what does it look like? That's the question that matters. To begin that discussion, we note the difficulty in applying the actual malice standard to our facts. As we explained, the actual malice standard's primary purpose is to protect media commentary on matters of public concern. Here we deal with a controversy that began as a private email sent by one parent to a co-parent addressing a parenting concern about their daughter. That private communication was shared by a third party, and the third party viewed the statements in the private email as justification for creating a public dispute that involved other parents, school officials, and the police. The actual malice standard seems a poor fit for the dispute between Miller and Watkins when that standard is calibrated to deal with the media. Uh-oh. So this is citing Cummins versus Bat World Sanctuary, describing the evolution of the actual malice standard and stating that neither the U.S. Supreme Court nor the Texas Supreme Court has seen the need to adjust defamation law in light of the changes in technology. Because the actual malice standard involves media behavior, the standard often involves determinations of whether the investigative work of the media was done in a way that reveals actual malice. These standards provide little guidance on what we have already described as a she said situation, in which Miller claims that Watkins has abused her daughter by making her sleep on the floor and has trolled and stalked Miller's social media accounts, and in which Watkins asserts that those claims are false. In this unique situation, we conclude the fact that the party stories are so at odds with each other provides evidence supporting an inference of actual malice. Whoa! Whoa. That's a powerful statement. Look, they disagree. Therefore, actual malice. I'm sorry. That's what it takes? That's amazing. Like, that section is a stunning thing. As a beginning point, to say the standards governing the actual malice determination are imprecise is an understatement. The standards turn on the subjective awareness of the defendant, and an injurious motive impacts the determination, though that motive is not determinative. This is, okay, let me translate that. If someone is trying to cause injury, that malice is a factor in whether or not it's actual malice. It's not sufficient on their own to show actual malice, but it is a factor that contributes to the calculus. And that's a big thing. Again, there's a fat guy on law Twitter. What was that guy's name? The fat one with the puffy face, and everybody thought he was his brother for a while, and that guy's a weirdo too, into like Shintow blogging or whatever. Also turned out not to be a practicing attorney at all, like his license had even lapsed or whatever. That guy was like, nope. There is no malice in actual malice. And so, that was, that's just wrong. That's just wrong. Yeah, Freezing Moon, please stop spamming. You're welcome to say whatever you want. Just please don't spam it over and over. Okay. The Tyler Court of Appeals recently explored the parameters of the actual malice determination as follows. To establish actual malice, a plaintiff must show a defamatory statement was published with either knowledge of its falsity or reckless disregard for its truth. Reckless disregard is a subjective standard focusing on the defendant's state of mind. Mere negligence is not enough. Rather, the plaintiff must establish that the defendant, in fact, entertained serious doubts as to the truth of this publication or had a high degree of awareness of the probable falsity of the published information. The evidence must be viewed in its entirety. Further, a defendant's state of mind can, indeed must usually, be proved by circumstantial evidence. Specifically, the Supreme Court stated the following. A lack of care of an injurious motive in making a statement is not alone proof of actual malice, but care and motive are factors to be considered. An understandable misinterpretation of ambiguous facts does not show actual malice, but inherently improbable assertions and statements made on information that is obviously dubious may show actual malice. A failure to investigate fully is not evidence of actual malice, a purposeful avoidance of the truth is. In addition, the Supreme Court stressed that proof of actual malice is not defeated by a defendant's self-serving protestation of sincerity. So they can't say, I was super serious and I totally believed it. Nope, that does not work. Again, something Law Twitter said was sufficient, that Ron Toye said, no, I believed it, and that he believed it was sufficient to overcome actual malice. That's not correct. That's not the case law. Go figure. Again, these... oh, boy. Never mind. I'll start drinking in a minute. All right. Now that we have sufficient hydration and protein, let's get a little pissed. No, the easy cop-out doesn't work, Diamond Duck. Even though, again, according to Law Twitter, this is all just an academic exercise. Of course, they have no idea what they're talking about. I can't stress that enough. I'm not going to drink as heavily as last night, don't worry. But a little whiskey to lubricate is always good. Okay. In searching for guidance, actual malice must be established by clear and convincing evidence. In searching for guidance to decide how the actual malice standard applies to our facts, we note that the United States Supreme Court in St. Amant versus Thompson held that evidence that a story had been fabricated may be evidence of malice. Texas Supreme Court relied on the following language from St. Amant when describing the actual malice standard under Texas law. Let's see. The defendant in a defamation action brought by a public official cannot, however, automatically ensure a favorable verdict by testifying that he published with the belief that the statements were true. The finder of fact must determine whether the publication was indeed made in good faith. Professions of good faith will be unlikely to prove persuasive. For example, where a story is fabricated by the defendant, is the product of his imagination, or is based wholly on an unverified anonymous telephone call. Or maybe an unverified anonymous forum called Pretty Ugly Little Liars. I mean, maybe that one too, but I don't know. Nor will they be likely to prevail when the publisher's allegations are so inherently improbable that only a reckless man would have put them in circulation. Likewise, recklessness may be found where there are obvious reasons to doubt the veracity of the informant or the accuracy of his reports. Though they are not a precise analogy, cases dealing with allegations of sexual assault provided some guidance on how to apply the actual malice standard in a case in which the private party's stories were dramatically opposed. For example, a federal district court in Kansas dealt with a defamation claim based on a Facebook post accusing the plaintiff of a rape that had occurred in a private setting. The plaintiff denied that the sexual assault had occurred. Chastain, that's the case, explained how the fact that the parties' stories were at odds prevented the dismissal of the case for a failure to provide evidence of actual malice as follows. Defendant states that plaintiff cannot provide evidence that defendant knew the allegations regarding the sexual assault or attempted rape were false, and therefore cannot show actual malice. The court finds defendant's arguments unpersuasive. In her Facebook post, defendant stated that plaintiff sexually assaulted or attempted to rape her, going into great detail in her narrative. Such recounting from defendant's perspective necessarily requires a lucid memory of the event as experienced by defendant herself. Of course, if the event forming the basis of defendant's accusation never occurred, as the court is required to assume at this stage, such a first-person narrative would require that defendant knew that the events were false because she necessarily never experienced them. I don't know why this isn't obvious. Of course this is how it has to work. And yet, a bunch of fat dumbs on law Twitter swore up and down that me saying Vic denying the allegations was not sufficient. Yet, here it is. Again, I cannot express how badly Chup fucked this up. He was required to take the factual scenario and assume it didn't happen. He was required to look at it that way. And he didn't do it. He was weighing evidence. Chup, you don't get to weigh evidence. It's not a trial, buddy. Vic's side is to be believed. That's it. If defendant knew that the events were false and nonetheless wrote the detailed narrative describing exactly how plaintiff had sexually assaulted or attempted to rape her when it actually never occurred, it is axiomatic that she wrote the narrative with actual malice or actual knowledge that it was false. Obviously. Of course. It's the only way you could do it. I had an entire argument. Again, it's on my old account, so it's long gone. An entire argument where I asked a law Twitter person if I came into their house and then left their house and suggested that they had raped me, that they would not be able to prove actual malice by denying the rape occurred. Of course they could. They're like, nope, I can't do it because these people are dumb. These people are done. Linda Marie says, without a crystal ball. Oh, yeah, that's another one today. By the way, if you go check out my Toddy versus without a crystal ball video that I did a while back in December, I was like, jurisdiction, where is it? Probably, without a crystal ball, probably a raging bitch because she never had a good donut in Minnesota. Her case got dismissed/yeeted for jurisdiction, so Emily D. Baker and maybe Uncivil Law will want to know your Minnesota law's opinion. Collab with them and Nate soon, please. Glad Emily introduced me to you 3 months ago. Yeah, I'll gladly talk to him about it. I think that the jurisdiction question was the most obvious question that existed in that case. Without getting to anything else, the jurisdiction question was baffling to me. Why are you bringing this in Washington? Okay, Matt Fields says, I feel a whiskey rant incoming. Fire, 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 fire. I showed up at the right time. Fire, 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 fire. We'll see. We'll see. You loved my court stream today? I know, it was great. As Chastain also explained when denying a motion to reconsider, because defendant and plaintiff were the only two direct actors in events that either did or did not occur, plaintiff's claims of falsity supports both that the statement was false and that the defendant necessarily knew it was false at the time she said it, because according to him, it never occurred. I cannot express how wrong Law Twitter is on this issue, and similarly how wrong Judge Chupp was on this issue, and it pisses me off that Judge Chupp being wrong may be. I have to remind everybody, because white pills are not allowed here, no whites allowed, that may still be why this case does not go through. The trial court shouldn't be at this stage, but is the arbiter of facts and evidence. And the appeals court can just agree with Chupp. They can do it. In Ratner versus Kohler, another federal court dealt with a similar fact pattern as that in Chastain. Ratner highlighted that it was operating, as are we, outside the usual ambit of a journalistic setting. As Ratner explained, this case is not a defamation case against a publisher or a journalist investigating events about third parties. Rather, the complaint here alleges that defendant Kohler knew her Facebook post was false when she published it because the event she recounted never took place. Plaintiff Ratner alleges that defendant's Facebook post was wholly fabricated. Ratner held that a dispute regarding whether an event had occurred was evidence of fabrication and relied on California authority of similar import to the language we quoted from the Texas Supreme Court's Bentley opinion, where the California courts held that actual malice may be inferred if the plaintiff demonstrates that the defamatory statement had no basis in fact, was fabricated by the defendant, or was the product of her imagination. Even if it was imagined, which kind of runs against the idea of maliciously creating something. But if they've created a false scenario in their head, that doesn't get to be a defense either. Another dumb fucking thing some fat non-lawyer on law Twitter said was, oh, well, I mean, if they created it in their head, but they believed it, then it's not actual malice, because that's not false, because they believe that it happened. Oh, okay. We could just lie about people as long as we just didn't try to make it up. That's fine then. Ruin their lives over fiction is okay if you just were too dumb to know that it wasn't real. Fuck you. Here, Watkins denied that she had stalked Miller on Facebook and had made fake profiles so that she could friend Miller and watch her social media. Later in her declaration, Watkins stated, "I never created fake social media accounts for any reason. I do not share Miller's posts." Watkins denied that she had taken everything out of her daughter's room and had forced her to sleep on the floor of her bedroom as a punishment for being friends with Miller's daughter. Watkins attached a photo to her declaration showing that her daughter's room was furnished and asserted that the photo showed the state of the room at the time when Miller had accused Watkins of removing the furniture. Watkins' declaration stated that Miller knew that the claims that she had made against Watkins were false and were known by Miller to be false. The only statements that Miller made in her declaration about what she suspected Watkins has done were as follows. "I suspect that Michelle Watkins created a fake social media account to spy on me because Michelle Watkins sent photos of my Facebook profile to others. I question whether Michelle Watkins' behavior was a crime because it did not seem right. I asked the local police department what the law was, but they referred me to Aubrey Independent School District's complaint process. Watkins objected to this paragraph and the trial court sustained the objection. Miller raises no issue on appeal that the trial court erred by sustaining the objection." Okay, so we have two differences between this and the Vic case. In Vic's case, we don't know whether or not Vic's declaration will be allowed in. It was not struck. It is part of the record. The trial court chose to ignore it. That should be reversible error literally by itself. Well, the plaintiff submitted evidence. It's in the record. We didn't rule that it should be struck, but we just chose to ignore it. That should be a reversible error. That alone should reverse the trial court's decision right there. Because not only can you not ignore evidence submitted by a plaintiff, like you have to strike it if you're going to strike it. You have to rule on the objection to the evidence. You have to strike it. And then they can challenge your strike if you're going to strike it. But if you don't strike it, not only can you not ignore the evidence at the TCPA stage, you must read that evidence favorable to the plaintiff. So you can't do what Chupp did. I hate this. I hate it because what Chupp did is legally impossible to do. I mean, judges do legally impossible stuff all the time, but you can't. If there were a fucking police department that police judges, Chupp would be arrested and executed on the spot for this and for public masturbation. But that is what would happen because he didn't do the thing that he had to do. Watkins also presented evidence of an injurious motive on Miller's part. As we have noted, the other parents who filed declarations stated that Miller had said that she was going after Watkins and that she had used Facebook to retaliate against parents with whom she disagreed. Further, Miller apparently made efforts to have Watkins removed from teaching the art class in question and from the school, but she tried to retrench by claiming that she had done so only after the school had lied about what her daughter had said. This is circumstantial evidence that Miller herself apparently feared how her statements and actions might throw her motive into question. To determine if there is prima facie proof of actual malice, we look to circumstantial evidence of whether, from a subjective viewpoint, the defendant in fact entertained serious doubts as to the truth of his publication or had a high degree of awareness of the probable falsity of the published information. Here, one private party claims that acts occurred, the other private party denies that the same acts occurred. The events here occurred in circumstances unlike those that traditionally involve actual malice where the basis for a journalistic claim can be tested. In essence, each one claims that the other is lying, and we have no means to decide who speaks the truth. If Miller indeed fabricated her allegations, then she, by definition, entertained serious doubts about them and had a high degree of awareness of the statement's falsity. Of course she did. Further, though an injurious motive is not determinative of actual malice, it is a factor that may be considered. Here, Miller's words and actions create an inference of an injurious motive. Miller's ire that Watkins had made the statements about her, although the statements were made to the limited audience of Watkins' ex-husband, is obvious. Her words were that she was going after Watkins and that her social media posts were a method of retaliation. This evidence raises an inference of an injurious motive, and in combination with the other evidence is relevant to Miller's subjective belief regarding whether her statements were true. The record supports an inference that Miller acted with actual malice. And of course, there is evidence that they were acting with an injurious motive. Tons of it. And I believe those tweets are in the record. Hard to say, but I believe so. With regard to the fourth element of defamation, there's prima facie proof that Watkins has suffered damages. Because the statements by Miller that we conclude are defamatory constitute defamation per se, it is presumed that Watkins has suffered general damages. Even if we could not rely on a presumption, Watkins presented prima facie proof that she has experienced mental anguish. This alone. Remember what Chup asked for? Literal dollar values? This lady just says mental anguish? That's it? That's enough? That's enough damages. Reminder. Hey, King Dre, will you stop spamming, you weirdo? Fuck me. Can we... There we go. As we noted above, though the terms have fallen out of favor in describing the defamatory sting of a statement, the terms defamation per se and defamation per quad remain viable in determining whether the statement produces a presumption of damage. The distinction between defamation per se and per quad is as follows. Historically, defamation per se has involved statements that are so obviously hurtful to a plaintiff's reputation that the jury may presume general damages, including for loss of reputation and mental anguish. A statement that injures a person in her office, profession, or occupation is typically classified as defamatory per se. Defamation per quad is defamation that is not actionable per se. Again, accusing someone of a crime or having a foul or loathsome disease or of engaging in serious sexual misconduct are examples of defamation per se. All of this, of course, applies to Vic. The existence of defamation per se permits a presumption of general damages, though that presumption is subject to qualifications depending on the context of the statement, as the Texas Supreme Court has explained. Actual or compensatory damages are intended to compensate a plaintiff for the injury she incurred and include general damages, which are non-economic damages as for loss of reputation or mental anguish, and special damages, which are economic damages such as lost income. Historically in Texas, defamation per se claims allow the jury to presume the existence of general damages without proof of actual injury. But the First Amendment requires competent evidence to support an award of actual or compensatory damages when the speech is public or the level of fault is less than actual malice. Thus, the Constitution only allows juries to presume the existence of general damages in defamation per se cases where the speech is not public or the plaintiff proves actual malice. So there you go. Also, prima facie proof of a viable defamation per se claim frees the party responding to a TCPA motion to dismiss from having to present clear and specific evidence of general damages. Pleading and proof of particular damage is not required to prevail on a claim of defamation per se, and thus actual damage is not an essential element of the claim to which the TCPA's burden of clear and specific evidence might apply. Here, Miller accused Watkins of two potential crimes: child abuse and online impersonation. Further, Miller's allegations that Watkins is an evil and vindictive mother, as demonstrated in part by her abusive actions towards her own daughter, would strike at Watkins's ability to be a substitute teacher and obviously were used by Miller for that purpose. Thus, we consider these statements to be defamatory per se. Further, to the extent that the statements have a public component, we have also already concluded that Watkins presented prima facie proof that the statements were made with actual malice. Thus, we conclude that the presumption of general damages frees Watkins from having to present prima facie proof of damages. Alternatively, if we are wrong in applying the presumption of general damages, then we conclude that Watkins presented prima facie proof of mental anguish. Generally, mental anguish is only compensable if it causes a substantial disruption in daily routine or a high degree of mental pain and distress. In essence, proof of compensable mental anguish looks to the degree of emotion it produces. In a sufficiency review, we must distinguish between shades and degrees of emotions, such as between disappointment and severe disappointment, between embarrassment and wounded pride, and between anger and indignation. We apply a traditional no evidence standard to a mental anguish finding to determine whether the record reveals any evidence of a high degree of mental pain and distress that is more than mere worry, anxiety, vexation, embarrassment, or anger. But generalized conclusory descriptions of how an event affected a person are insufficient evidence on which to base mental anguish damages. Watkins's declaration contains more than conclusory and superficial descriptions of the anguish that she claims to have suffered, as shown by the following. Okay. Woo! Timothy Reaper got an axe by mistake. I can't undo a timeout, unfortunately, so he'll be back in 300 seconds. There's nothing I can do. All right. I love teaching art. This past 2019 to 2020 school year was my second year to do so. It's my first year in charge of the Meet the Masters program at Brockett Elementary. Before all of Carly Miller's actions that are a part of this lawsuit happened, I would dress up like the artist or from the time period to engage with the students. After Miller did what she did and is continuing to do, I did not dress up as often. When I did get dressed up, I would get very anxious each time before I knew Miss Miller was going to be at school to help with her children's classes. She had never helped as a parent volunteer in the art room for all the years I had taught the art program. I knew that she was saying false things about me, and her presence in the classroom was frightening and intimidating and extremely upsetting. By the way, this is a conclusory statement right here. But the lack of dressing up as much as not. A few days after Miller made her Facebook post that is attached to Kelly Casey's declaration in Exhibit 2, Miller was up at the school decorating for an event. I would have normally stayed to help with decorating, as I have done for almost every event, but I did not feel comfortable. I said hello to my friends and left. The stress of knowing that she could email the school or that I would have to talk to the principal about her demands was causing me to be anxious, and my stomach would often hurt. Here we go. Causing me to be anxious? Nope. Stomach often hurting? Yes. I felt uneasy going to the school for any reason, in fear she might be there or show up. I saw my regular doctor to discuss any options for my stress or anxiety. Yes. By the way, Not legal advice, but if you're experiencing mental anguish or trauma, like legitimately from someone's actions, start getting a record of it. Start getting a record of it. TLJ Screwjob is right. Vic mentioned taking antidepressants in his deposition. But this is one of the big areas where people screw up on these claims. They're like, oh, I'm suffering mental anguish. I can't go outside. I can't do anything. Did you go to a doctor? Well, no. Then it must not have been that bad. Go to a doctor. I also started counseling with Janie Grimes, who has since retired. Yep, counseling is good. I discussed the situation involving Miss Miller many times during my sessions. When Miss Miller was in the classroom, I would do my best to teach and focus on the children, but her hostile presence would be very distracting. I've broken down in the school a few times when I just could not hold in my stress from her constantly attacking me on Facebook and to the school. There you go, broken down. That's great. It's not great that she broke down. It's great that she's demonstrating the mental anguish. Once she falsely accused me of abusing my daughter to the school and to peers, I felt she had taken it too far. The fact that she would bring my daughter into the middle of this issue was very upsetting. This affected both my daughter and me because I was having to discuss adult issues with her about Miss Miller. I usually keep my children out of adult matters, as they do not need to be concerned or worried at their ages about those things. The weight of her continuous false claims against me has affected my overall physical and mental well-being. I've gained weight. No! Put Miller in jail. When women gain weight, we need it to stop immediately. Put Miller in jail. Execute her. Guillotine. I don't care. This is the true crime. I've gained weight since last fall, 2019. I have taken less interest in things I usually enjoy outside of the classroom. I took time off as a substitute teacher this year because I wanted to focus on art. My plan was to continue to teach art next school year, but unless things improve materially, I just do not feel I would be able to focus properly on the art and the students, knowing Miss Miller would or could cause any more mental or potentially physical harm to me or my family. Watkins relatively, listen to the impact of this Karen. It's really terrible. Watkins' relatively detailed statements of the anguish that she suffered establish prima facie proof of mental anguish damages. In reaching this conclusion, we rely on opinions from the Texas Supreme Court reviewing mental anguish awards on appeal and compare the holdings of those cases to Watkins' statements. Following are examples of the Supreme Court's descriptions of emotions that were sufficient to sustain a finding of mental anguish. The plaintiff testified that he lost time with his friends and family, spent time worrying at home, and was distressed about the impact of the defamatory statements had on him and his family within their community. A widow whose husband's grave was desecrated testified that she was anxious for years about whether her own grave would be desecrated, was afflicted with headaches, could not sleep, and suffered stress that caused burning in her stomach. She sought medical treatment for these issues and was prescribed medication for anxiety and depression. Testimony of plaintiff reflected a substantial disruption in his life. His familial relationships were impacted, his demeanor changed, he was unable to sleep, and he was treated for anxiety and depression. By comparing Watkins' testimony to the quoted descriptions of emotions that would support a recovery from mental anguish, we conclude that she presented clear and specific prima facie evidence of mental anguish. Watkins' routines at school and with her daughter have been disrupted. She claims that she has experienced physical symptoms from the emotions produced by Miller's actions. She has discussed the stress produced by what she has experienced with medical care providers. She's altered her work plans. At this preliminary stage of litigation, such evidence carries Watkins' burdens to present clear and specific evidence that she suffered mental anguish. One of Miller's arguments that we have not addressed is that Watkins failed to plead her claim adequately, and for this reason, the trial court should have granted the motion to dismiss. We are unsure what to make of the argument. The TCPA provides that the trial court is to consider the pleadings and evidence in resolving a motion to dismiss. We have detailed the evidence that Watkins presented. We also noted that Watkins... Oh my God! Hold on, I just realized what's going on. We also noted that Watkins filed a supplemental petition that went into elaborate detail outlining the statements that Miller allegedly made. Further, Miller cites no case to support her position that a case in the procedural stance of this one could be determined based on a defective pleading. There's a question of whether a party responding to a TCPA motion to dismiss may rely solely on its pleadings, to present evidence of a prima facie claim, but Watkins went far beyond reliance on her pleadings in establishing her prima facie case for defamation. Wow. Wow, that's amazing. Let me translate what just happened. They basically said even if her pleading was not sufficient, the TCPA doesn't automatically work because of an insufficient pleading. I mean, that is a stunning development. Again, that is absolutely crazy. The idea that if they submit evidence, the insufficient pleading doesn't matter. Miller's brief is so deficient that she has waived any argument that Watkins failed to present clear and specific evidence supporting the elements of her tortious interference claim. Woof. Watkins also, so this is a briefing issue. This won't be related to Vic's case for his opponents because his opponents don't have to overturn the decision. Vic has to overturn the decision. So this would be applied to Vic. If his briefing was not sufficient, they could say that. So we'll see. Watkins also sued Miller for tortious interference with her contract to act as a substitute teacher. Trial court found that Watkins has satisfied her burden of proof to proceed on her causes of action for defamation and tortious interference. Can you imagine if Vic had gotten this judge? Can you imagine? This judge would have been a completely different story. The lower court judge. Trial court found that Watkins has satisfied their burden of proof to proceed on her cause of action for defamation and tortious interference. Miller's brief, for the most part, drops the question of whether the trial court erred by finding that Watkins had carried the burden on her tortious interference claim. Miller's brief contains exactly 2 references to the term tortious interference. The extent of Miller's argument dealing with that cause of action is as follows. Here, Watkins failed to establish facts by clear and convincing evidence that supported her defamation and tortious interference claims. Watkins filed into the clerk's record a business records affidavit of Aubrey Independent School District and attached records and 4 supporting declarations. The business records provided by Aubrey Independent School District support the fact that Miller followed proper channels for complaining about an approved and qualified substitute teacher and volunteer. The Aubrey Independent School District records support the fact that Miller petitioned the school district through its formal and informal complaint processes. So they were arguing privilege here, but they didn't do very well in arguing it. Watkins conceded in paragraph 25 of her declaration that was her own decision to not teach. Watkins stated that Carly Miller tried to get my contract terminated or revoked, but later stated that ultimately it would be Watkins' own fear and not Miller's attempt to get her fired that would keep Watkins from teaching. Watkins conceded in paragraph 29 of her declaration that she had yet to lose her ability to substitute teach. Watkins presented no evidence that Miller's actions rose to the level of tortious interference with actual or prospective contract, because Watkins was at all times in full control over whether she wanted to substitute teach. Watkins testified in her declaration that it was her own decision to not teach. Miller's brief lacks citation to any authority addressing tortious interference and does not state how, in the context of a TCPA motion to dismiss, a party presents prima facie proof of a legal action asserting that cause of action. The brief does not even cite authority outlining what the elements of the cause of action are. We have strived mightily to coax out arguments testing whether Watkins presented prima facie proof of the elements of a defamation claim, but it is beyond our role as an appellate court to take on the job of completely briefing and then arguing a party's appeal for her. Miller waived error on the issue of whether there was a prima facie proof of Watkins' tortious interference action by inadequately briefing her argument. See Texas Rule of Appellate Procedure 38.1. The brief must contain a clear and concise argument for the contentions made with appropriate citations to authorities and to the record. Essentially, Miller leaves it up to us to brief her issue, and we have no duty to do so. Because Miller's argument is inadequately briefed, we hold that it is waived. So don't do bad briefing. That's a life lesson for everybody. Woo! It is toasty in this office. Oh my God. On the record before us, Miller has not established that this case should be dismissed because Watkins failed to comply with the Texas Defamation Mitigation Act. This probably won't apply to Vic's case because they did not argue at the trial court level that they didn't follow the TDMA. Miller argues that Watkins lacks standing to sue her for defamation because she failed to comply with the Texas Defamation Mitigation Act. In support of this argument, Miller makes a categorical assertion that Watkins failed to comply with the Defamation Mitigation Act because she never requested a retraction of Miller's allegedly defamatory statements. Watkins' declaration, however, states that she did seek a retraction. Further, the Mitigation Act requires a timely challenge. I brought this up to the sufficiency of a retraction request, and the record contains no indication that a challenge was filed. Boom. We overrule Miller's argument because she fails to establish that the error she asserts actually occurred or that any potential error was brought to the trial court's attention. Texas Supreme Court recently explained the history and function of the Defamation Mitigation Act as follows. The DMA was enacted in 1993 to provide a method for a person who has been defamed by a publication or broadcast to mitigate any perceived damage or injury. The statute advances that objective by providing sticks and carrots to induce plaintiffs and defendants to take prompt action to rectify defamatory publications, so any ensuing damages are ameliorated. The Act applies to all publications in whatever form and all claims for relief, however characterized, from damages arising out of harm to personal reputation caused by the false content of a publication. The moving parts of the Mitigation Act in broad outline form are as follows. Section 73.055A provides that a person may maintain an action for defamation only if the person or an authorized attorney or agent made a timely and sufficient request for a correction, clarification, or retraction from the defendant, or the defendant has actually made a correction, clarification, or retraction with or without a request. Section 73.055B states that the request is timely if made during the period of limitation for commencement of an action for defamation. So during the statute of limitations, the request is, specifies on whom the request should be made and the terms that it should contain, limits the recovery of exemplary damages if the request is made more than 90 days after receiving knowledge of the publication, specifies what constitutes a timely and sufficient correction, clarification, or retraction, provides how a defendant may rely on a correction that it issues, and when a defendant must challenge the sufficiency and timeliness of a request, which they did not do here. This is the stage they really failed in Vic's case. Provides that if a correction, clarification, or retraction is made in accordance with this subchapter, regardless of whether the person claiming harm has made a request. Goodness. A person may not recover exemplary damages unless the publication was made with actual malice. Miller's argument recites various parts of Section 73.055 and then makes the following two-sentence argument. Here it is impossible for Watkins to meet the clear and convincing standard required by the TCPA because she failed to provide any evidence that she satisfied the statutory conditions precedent to bring her claim. Watkins did not have standing to bring the suit for defamation. Miller's brief does not give any record citation showing that she raised this argument in the trial court, and we cannot find such argument in the record. Watkins responds to Miller's argument by attaching to her brief a letter requesting retraction that she allegedly sent to Miller, and Miller's counsel's response to the letter. Well, that's a mistake. Although it is not surprising that the letters are not part of our record because the issue is not raised in the trial court, we may not consider the letters that Watkins attached to her brief because they are not part of the appellate record in this case. But it doesn't matter. We cannot consider documents attached as appendices to briefs and must consider a case based solely upon the record filed. However, the record refutes Miller's statements that there is no evidence that Watkins complied with the DMA. First, Watkins' declaration filed in support of a response to Miller's TCPA motion to dismiss states, Carly Miller's claim that I filed a lawsuit against her without any warning is false. My attorney sent her a letter seeking a retraction of her false claims and statements about me before the lawsuit was filed. Carly Miller made no response to the letter whatsoever. The lawsuit was not filed until after she failed to respond. And second, Miller testified at one of the hearings conducted by Aubrey Independent School District that her lawyer had drafted an agreement. I'm praying that she does the agreement that my lawyer has set up, but we still don't know. Miller also fails to acknowledge the provision of the DMA that requires her to raise a challenge to the sufficiency of the request for retraction in the trial court. Specifically, if a defendant intends to challenge the sufficiency or timeliness of a request for correction, clarification, or retraction, the defendant must state the challenge in a motion to declare the request insufficient or untimely served not later than the 60th day after the date of service of the citation. In Vic's case, they only did this in their response, not in a motion, and therefore it is invalid. They didn't raise this issue on appeal, but it is invalid. The Texas Supreme Court described this provision as explicitly and unequivocally placing the onus on the defendant to raise an objection within 60 days after being served with the defamation lawsuit in order to challenge the sufficiency of a request for correction, clarification, or retraction under Section 73.055. The Supreme Court went on to state that the DMA explicitly puts the burden on defendants in a defamation lawsuit to timely object if the section has not been satisfied and point to a change if they think it will reduce their damages exposure. Neither Miller's brief nor the record contains any suggestion that she invoked the section to challenge the request for retraction that the record indicates that Watkins sent. Jose Gonzalez says, "Yeah, I am Farmer Nick. How are you all?" Oh, wait, no. Yeah, I'm Farmer Nick. How are you all? It's y'all. How are you, y'all? How are y'all? There you go. The burden is on a party appealing from a trial court judgment to show that the judgment is erroneous in order to obtain a reversal. Here we face an argument that relies on a factual statement that no request for retraction was made when the record contradicts that statement. And the uncertainty regarding whether a request for retraction was made then raises another question that we are not in a position to answer: whether Miller waived a challenge to the sufficiency of the request for retraction by failing to challenge as required. We cannot guess our way to a resolution of Miller's argument. Miller's brief also fails to recognize that there is a split of authority on the issue of whether the remedy for failure to comply with the DMA is a dismissal and that the issue is presently pending before the Texas Supreme Court. So there you go. We have addressed the arguments. We have addressed the arguments that Miller raises in support of her first issue and have rejected them. Accordingly, we overrule Miller's first issue. We reject Miller's argument that Watkins' request for injunctive relief should be reviewed as a discrete legal action that is subject to dismissal under the TCPA. Okay, so Watkins must have requested an injunction from the court to have people stop, or to have Miller stop defaming her. In her second issue, Miller attacks what she characterizes as Watkins' third cause of action: Watkins' request for temporary injunctive relief. Miller offers a litany of reasons why a request for injunctive relief is invalid and should have been dismissed. These include that the request is an attempt to change the parenting arrangements ordered in a decree of divorce between Watkins and her ex-husband, and that an injunction would impair Miller's ability to exercise a number of her constitutional rights. The fact that the trial court did not grant any injunctive relief and stated that it would not impose a prior restraint on Miller's speech. But more fundamentally, Miller's attack is misdirected. Watkins' request for injunctive relief is not a separate legal action to which a TCPA motion to dismiss may be directed. A TCPA motion to dismiss is directed to a legal action. If a legal action is based on or in response to a party's exercise of the rights to free speech, right to petition, or right to association, that party may file a motion to dismiss the legal action. It is not the consensus of the intermediate appellate courts that a request for injunctive relief is not a discrete legal action that is subject to dismissal under the TCPA. Instead, the temporary injunction is a remedy that is available only if a probable right to relief has been established in connection with a cause of action. So, if you're watching the upload of this, currently YouTube has gone ahead and stopped playing the stream. Don't know what that's about, but we're still recording. Waiting for the stream to come back. Not sure what's going on or when it will be back. Just kind of stuck here. Watching the ring, watching the viewers disappear. Thank you to YouTube for this. Oh man, is it great. Boy, do I love when YouTube does this. So, by the way, I guess bonus for anybody who's watching this later, for all of you people suggesting that that this is on my end, it's not. I'm participating in the chat, which means my upstream is actually working. For whatever reason, YouTube has just decided to stop accepting data. I don't know what it is. I haven't gotten any sort of email or anything like that. There's no claim on the show. It's just YouTube streaming. This is great. It's always fun when YouTube does this and completely kills the momentum of a stream. Uh I don't know if we'll be back. It's not going down. That's the crazy thing, is YouTube's not going down. My bitrate is consistent. My bitrate is way above normal. My bitrate is double my actual upload rate right now. I don't know what's happening. Hey, we're back. We're back. We're back. Well, that was fun. The answer to your question on if I ever want to move a stream over to Twitch, no. I never want to move a YouTube stream to Twitch. may end a YouTube stream and go stream on Twitch or something. But no, I do not want to move a stream over there. I'd finish it the next day. So now I'm going to have to, I had to end the stream on my end and restart it. I guess that fixed it. So I'll have to go ahead and splice these two things together, which will just be a ton of fun. Just a ton of fun. So thank you to YouTube. Thank you to YouTube for that. It's always great fighting a never-ending uphill battle to try and make YouTube money. God. Okay. We have one page left. There's nothing left. Ugh. All right. So, we'll go ahead and get this thing done. Man, I'm melting. A TCPA motion to dismiss is directed to a legal action. If a legal action is based on or is in response to a party's exercise of a right of free speech, right to petition, right of association, that a party may file a motion to dismiss a legal action. It is the consensus of the intermediate appellate courts that a request for injunctive relief is not a discrete legal action that is subject to dismissal under the TCPA. Instead, a temporary injunction is a remedy that is available only if a probable right to relief has been established in connection with a cause of action. So it's not a separate legal action. It is the same legal action, so you can't TCPA an injunction that is part of an existing legal action. The 14th Court of Appeals cataloged cases from various courts of appeals, including our own, holding that a request for injunctive relief may not be separately challenged under the TCPA as a discrete legal action. Specifically, the 14th noted that at least the 1st, 2nd, 3rd, and 5th Courts of Appeals have determined the TCPA does not allow a request for injunctive relief to be separately challenged when it is linked to a cause of action. Holding that TCPA did not apply to daughter's request for injunction prohibiting father from contacting daughter through any means of communication where injunctive relief was dependent on daughter's underlying claim for father's wrongful act of assault. Stating that injunctive relief was a remedy tied to a defamation claim and a remedy request is not separately challengeable apart from the cause of action to which it is linked. Holding that injunctive relief is a remedy, not a standalone cause of action in suit for tortious interference with the contract, tortious interference with prospective business relations, and defamation. Declining to review separately trial court's denial of TCPA dismissal of injunctive relief because it was ancillary to defamation claims already reviewed, we agree with these sister courts. Thus, up to this point, our opinion has focused on whether there is a prima facie proof of the causes of action asserted in Watkins' legal action, not the viability of ancillary relief that she sought but did not receive. We will not address whether the trial court should have separately dismissed her request for injunctive relief when the ancillary relief is not a legal action properly subject to a TCPA motion to dismiss. We overrule Miller's second issue. Conclusion. Having overruled Miller's first and second issues, we affirm the trial court's order denying Miller's TCPA motion to dismiss. Dabney Bassel, Justice, March 11th, 2021. There we go. There we go. So, here we have the Second Court of Appeals in Texas upholding a rejection of a TCPA motion to dismiss on grounds that seem comparable to Vicks in the worst read of them. Comparable to Vicks in the worst read. This, importantly, this TCPA decision runs contrary to basically everything that Law Twitter said. Literally all of it. It frustratingly shows that their correctness on their predictions was was a function of the judge, really. I mean, a conclusion that I've talked about for a while. You can never, ever discount the human element in any case. You just can't. If you read that, I mean, you read this TCPA and you go, the law is clear. Vic should have easily passed TCPA. The law is absolutely clear on it. Where about in Texas does the Second Court of Appeals affect? Fort Worth. Same court. It's the same appeals court for Vic's case. So the good news is, if the appeals court is consistent in their application of the TCPA to Vic's case, at least the defamation should come back. At least against Ron and Monica. I would contend also against Jamie and Funimation. Those are a little bit tougher questions, but at least against Ron and Monica, it should come back. Based on my application of this case to Vic's facts, says Ron and Monica, it has to come back on the defamation. Jamie Markey's still a tough case. Always was a tough case, because she didn't say as much. However, let me be clear. I think Jamie and Funimation, under the read of this case, should also be brought back in. That's the good news. The bad news is we still have a human element, and that human element in this case is not limited to judges. That human element involves Ty and his team. It involves the defendants and their teams, and it involves the judges. And unfortunately, that human element in this case also relies on the remnants of the human element from Chup in the lower court. Chup's decision is an obstacle to overcome. This person, the obstacle didn't need to be overcome. The obstacle was overcome in the lower court by a competent judge. Yeah, I saw Duchette saying Vic will fail because of Mogid versus Lindemood. And again, when you read this case, no. It's important to remember that Ron alone tweeted 400 different things about Vic. That's in the record. It was attached to the deposition as an exhibit to the deposition. The entire deposition and the entire exhibit are in the record. They were included in the petitions. They were not rejected by the court. They were submitted by both parties. Those are all there. Ron didn't just call Vic a sexual predator. So if T. Greg wants to say, well, sexual predator is non-defamatory statement under this one case, okay, fine. 399 tweets to go, many of which say assault or assaulted. All you have to do, this case says it explicitly, it's not that you have to prove that every statement that you list is defamatory. It's you only have to show that any statement that you list is defamatory. Many of the statements in this case that were listed were not defamatory. The appeals court just kind of breezed past them and said, here are statements that are definitely defamatory for the purposes of TCPA. Now, when you bring back, when this goes back and the TCPA is defeated in this case, right? Not Vic's case. In this case, when they go back, they'll be able to bring all of their statements at trial if they so choose. And they get to fight over all of the statements. They get to say, you know, the appeals court just grabs the statements that they find sufficient to show a prima facie showing. But a prima facie showing isn't dispositive in either direction. So both parties will have an opportunity to fight over every statement in this case if it goes, now that it's going back. They get to fight over all the statements, not just the prima facie statements that the appeals court used. So let's say, hypothetically, Vic goes and the appeals court finds one statement from Ron that they find to be defamatory. So they send it back. Well, they still get to fight over all of the statements. All of them. Because they get to show the defamatory intent, the defamatory motive. They get to fight over that. I mean, and again, with Ron and this case, I honestly don't see how it doesn't go back, but I'm not trying to hype it because I'm negative on this. I don't see how it doesn't, and that concerns me because it very well might not. But there is so much defamatory motive, and it's all over the place. It's in his text messages. It's in his own deposition. Well, I didn't want him to go to the conventions. That's all. It's all obvious. But will it be enough? We don't know. We don't know. There's no way. Alex G says, I just found out that one of my old undergrad friends at UGA ended up in the same NC Central University graduating class as Low T Greg Duchette. Said Low T was always a shithead. No one is surprised by that. Was there any actual evidence in court? I'm arguing with somebody on YouTube and he claims there was. Huh? He claims there was. I mean, there was evidence in court. Yes, there's lots of evidence in the record. There's lots of evidence in the record. And again, like you guys have known my opinion about this forever. I literally believe that Chup screwed this up at the onset. I don't think there's any question about what happened in this case. So I unequivocally believe that this should have passed TCPA at the trial court level, and that this step should have been, I mean, they were still going to appeal it, but that should have been dealt with. That all this should have moved in Vic's favor and that he should be passed. Like, I've never changed that opinion. My opinion was not that there was not sufficient evidence. It was that Chup got it wrong. I meant the allegations having any proof. I should have been more specific. Oh, no. No, there's no evidence of anything. That's one of their problems. But it doesn't matter. To be fair to the person you're arguing with, there's no place for the defense's evidence to be weighed in a TCPA, generally speaking. There's no like, well, here's their evidence, blah, 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 blah. I mean, they could try and raise the affirmative defense of truth. They didn't frame it that way. They didn't do it that way. But, yeah. So the good news is, in this case, there is a ton of information about the TCPA, how the Second Court of Appeals is dealing with it right now. We can't really read into the timing of when this case is decided versus Vic's case. However, I think it's interesting that this case was decided before Vic's case. Again, you take this with a grain of salt, okay? This is literally me spitballing and theorizing, theory crafting, whatever you want to call it. Because there is nothing that I can back this up with at all. This case dealt with changes to defamation law that occurred after Vic's case was briefed. The appeals court could have could have sent a request to the parties to supplement their briefs on the issues of defamation relating to the recent decision by the Supreme Court to change how defamation works. The appeals court could have done that. Appeals courts can send out a notice to the parties and request updated briefing. Say, hey, this decision came down. This decision came down. Now we need you to go ahead and issue a new brief or supplement your old brief. I'm checking something real quick here. Here we go. Just a moment. I'm trying to show you what that looks like. Come on. Come on. This should not be taking a long time at all. Ugh. Come on. Oh my God. I wasn't thinking I would need to do this. I certainly wasn't thinking it would take this long to download a simple document. Do we have it? Invalid document show and path and show page routine. Good job. Thanks. Not helpful. I don't know if I'm going to be able to pull this document. So they did a, nope, it's broken. Good job. Well, anyway, in this particular case that we're reading, they sent a request for a corrected brief. So they could have done it. They could have sent out, that's my point. They didn't. So how do I read that? What's my weird sort of brain train on that say? It says Court of Appeals has two options. Importantly, the case was briefed a week before that Supreme Court decision came out, but they took it on submission in September, which is 3 months after that decision came out. So they, at any time in that 3-month period, could have requested updated briefing. They didn't. Why? Why? That's the question. If they rule on the briefing negative towards Vic, Vic can certainly request a motion for reconsideration and say that they didn't have the opportunity to argue the updated defamation standards that came out after briefing was complete. And they can motion for reconsideration based on this ruling as well. They can say that, look, based on the updated instructions on defamation from the Texas Supreme Court, combined with the ruling in Watkins v. Miller from this court, we would request reconsideration considering these elements that we believe are adverse to this court's precedential opinion in Watkins versus Miller. They can request that. The court doesn't have to give it to them, but they can certainly do that. And the appeals court knows they can do that. So they could have issued a request for an updated briefing, or they could not and just rule on the briefs as is. It is entirely possible that they will apply this, which they chose to rule on first, to Vic's case when they read it. And I think that would be only good for Vic. But I don't know. Okay, that's just what my brain says, trying to get in the minds of why judges are ruling on cases that are briefed 4 months later than other cases. Could Moron's cross appeal be affecting the ruling timeline? No, not that much. Because they consolidated their cross appeal timeline with their regular appeal timeline. They got it all. That was all resolved at the appeals court. So, that shouldn't be doing anything to this. And even if not, their cross appeal timeline was done still like 2.5 months before this case was briefed. So even though Vic's case is under the old Texas TCPA, the new rulings affect the old rules as long as it's in court. Yeah, because they're not ruling in Vic's case and in these other cases on a new aspect of the TCPA. What they're ruling on are the underlying issues of defamation. It's how the Supreme Court and how the appeals court understand defamation law, not how they understand the TCPA. Now, if there was some bit in there about procedural motion, like procedural postures under the TCPA, they'd have to distinguish between which TCPA it is. That's going to be dealing with the what legal actions. Really, it's going to be limited to what legal actions are considered legal actions under the TCPA, because that was the big change, clarifying what actually was a legal action in the original TCPA versus the updated one. With that said, those aren't at issue in any of these cases that I've seen so far. It's the understanding of defamation law in Texas, clarified by the Supreme Court. And that has nothing to do with the TCPA change. Could have wanted a stronger case to set the precedent and apply those precedents to Vic. Yeah, that's possible. Again, I'm really... Spectre says, also, this is an appeal of a TCPA denial, and the appeal for that is interlocutory, and Vic's is expedited, so it makes sense this came out first. No, it doesn't. All TCPA appeals are expedited. Even the non-interlocutory ones are expedited. So it doesn't make sense. And this one didn't come out in any sort of... This one had delays as well. This one was filed on 6/25. They had to, do a whole bunch of stuff. And get it done. But all TCPA appeals are expedited. So there's no... And again, we can't read into why. Like, I'm musing here, but you can't actually read into why they did it. I mean, they could have just decided that this was a case that they could decide. And they did it. That's all. The judge panel might have had less briefs to deal with because they denied some motions and just had more time to write the opinions. Who knows? It could be literally anything. So, very, very interesting case here. So in sum, though, whatever happens to Vic, if Vic is denied, he can use this case as a motion for reconsideration and on petition to the Supreme Court of Texas. Doesn't mean that he'll get either of those. But there you go. Diamond Duck, there weren't 400 tweets to go through. There was a lot to go through in this one. There was a lot to go through. Let's see if I can see. Now, the record in Vic's case is bigger. It is absolutely bigger than this case. Let me see if I can find anything about the record. How big it was. Vic's record was much, much bigger. Although Vic's record was not unheard of large either. So that's another possibility. I mean, they could be just taking their time. That's a good thing, by the way. If they take their time and review the record, that's good for Vic. The record is good for him. So, with this ruling, I am more optimistic than I was about Vic's chances. I'm still reserving my hope, and I'm certainly not offering hype. But I am more optimistic. Azurian, Ron's record, I think, is 354 tweets or something like that. Okay, so apparently all the documents are broken on this case now. Good job. Thank you. Great. But again, this case was submitted on January 20th, 2021. They issued their ruling on March 11th. Vic's case was submitted on September 22nd of 2020. We've got a significant timeline disparity. No idea what's caused it. Don't know anything about it. So, anyway, let's do super chats, wrap up a little earlier tonight, and then I'll go over to Twitch. We're going to watch The Whole 9 Yards because tonight is a movie night. We'll watch The Whole 9 Yards. I love that movie. Bruce Willis, Matthew Perry, Amanda Peet, Michael Clark Duncan, some other people. So that's what we're going to do. Although I've got to tell you guys something. I have a game of Risk of Rain 2 going that's just sitting on pause right now, and I want to finish that first. So I'm going to finish that real quick, and then we'll go to The Whole 9 Yards. So, but we will do that, and that'll be fun times. When are you going to watch 8 Heads in a Duffel Bag? I don't think it's on Twitch. Yeah, I did it just for Angry Baneling, so that'll be great. And then tomorrow night, we're going to start a new game. I haven't decided what game yet, but we're going to start a new game of some sort. So, oh, wait, mild, let me check. Amazon can make me a liar if they have The Last Boy Scout on Prime. They don't. There you go. Damn it. I want to watch that movie again. It's been a long time since I've watched that movie. But, okay. Anyway, let's do these chats, and then we will wrap up the show. Here we go. Where are we? Eddie says that last hour last night was legendary. Go on EFAP, you massive. You'd be a top tier guest. I'd love to go on EFAP. I'd love to do it. Night of Hope says, yeah, imagine that. It's almost like just because someone is a public figure, you shouldn't be able to claim they rape people when they aren't raping anybody. It's almost like you don't get a free pass to slander people just because they're publicly known. Weird. Weird that's strange. Oh, Santiago says, hey, Nick, where did the confused Russian character you and Drex do sometimes come from? Also, bring on Drexel. The simp population has overgrown. I don't know. It's from Snatch. You put the stone in the case. He's Uzbekistani, actually, right? Boris the Blade. You put the stone in the case. So open the case and get the stone. I'm guessing that's what you're talking about. Jane Doe says it's not racist if it's just the truth. When I lived outside D.C. in Annandale, affectionately termed Asiandale by the locals, I had the best Korean barbecue. Dungeon Master says, if I'm remembering correctly, Uncivil Law was of the opinion that Ty Beard didn't make as strong of a case as he could have. I love the Beard as much as the next guy, but could there be some truth to that, and could it maybe impact the appeals? We won't know until the appeals court issues their ruling. Yes is the answer. Yes is the answer. That's always possible. And it's something I talked about when reviewing the briefs. I did not give them universal praise. I hope the briefs were competent enough. I didn't say they were the greatest briefs I've ever looked at, only my own briefs. I didn't say anything like that. So, it's entirely up to the appeals court. What I did say was that the people drafting Vic's appeals were all competent attorneys who have significant appeals experience, and what I thought was a good appeal brief versus what they did doesn't really matter, because they're the ones with the clients that are making the decisions, and they're the ones with the relevant experience in Texas courts. Anyone who thinks that Ty is not a trial lawyer and has never done an appeal is wrong. There's nothing else to say about it. Anyone who thinks that An Lee or Mike Martinez are inexperienced lawyers who have not done appeals are also wrong. It's just not true. They've done more appeals than overwhelming majority of the people speaking have done. So I don't know what to say. I might have made different decisions, but again, I'm not a Texas lawyer with appeals experience, so I can only tell you what I would do and how I would approach things. But lawyers are going to have disagreements over what's important. I always bet on me, but, I'm not the one writing the stuff, so I can only tell you my opinions. Padre Speaks as Brisket Rule 1, always have 2 sensor thermometer. The thermometer wasn't the problem. The problem was the freezing cold wind and snow blowing the flame out in my smoke box. Polio64 says, stories written in books are objectively bad. Okay. Good luck showing that one. Andrew War Snowboard says, would you still not talk to the police after you called them over a cake donut? No, I would let them suffer the cake donut. I wouldn't expose them to the glory of the better donut. Alex G says, Maddox is streaming on Twitch right now. What can I say in his chat to trigger him and get instantly banned? Say, hey, it's been a long time. You should go on Rekieta Law's show and talk to him about your case. That should work. Permafrost says, Permafrost says a donut is just part of day-to-day life. Yes, that is it. Ugh. Look, a donut is not a great story. It's shit at storytelling. Donut storytelling is garbage. But man, do I love consuming donuts, right? I would consume donuts every day. Every day, I would consume donuts constantly if I had a good donut place around me. I just don't. But their storytelling ability is fucking garbage. Kyra Funny Valentine 2020 says, yo, Nick was arguing with a friend about the whole Texas winter storm. She argued that they have a cheap-ass dollar store power grid that's privatized, smelled BS, but didn't know how to respond. Thoughts? It looks like Texas has a weird set of protocols in place that artificially inflate wholesale prices on energy to control power grid demand at the wholesale level. And that, combined with temperatures that were extremely low, combined with a lack of ability because the feds wouldn't let them to open up other alternative power plants to make up for increased load, caused the blackout. That's what it was. Angry Baneling, God, Krispy Kreme donuts is not dope. Krispy Kreme donuts are fine. They're a low-tier donut. I don't know if you understand this. They're the Walmart brand of donuts. Krispy Kreme donuts are adequate if nothing else is around. God, India's the worst place. The only thing good to come out of India is kabaddi. Kabaddi is great. Everything else is bad. Kyra says, you got to give some love to kolaches too. Preach. Oh, I did. God, I love kolaches. Minister of Hygiene says, best donut I ever had was College Station, Texas. It's been 28 years and I still remember it. No one important says, Cinnabon is greater than donuts. Fight me, mate. Nope. They're not even comparable. They're different things. Spectre, Dunky's Donuts? Do you mean Dunkin' Donuts? Dunkin' Donuts is garbage. No, Angry Baneling, Krispy Kreme is not good in India versus sucking in the USA. Krispy Kreme is the same in India and the USA. India sucks. That's what you're missing here. Cinnabon is not greater than donuts. Stop it. You haven't had good donuts. Gothic Nerdshit says, books are the best method to tell fictional stories. My favorite is The Protocols of the Elders of Zion. Oh, wait. Come on now. How does a place that doesn't exist suck? Oh, dude. Krypton sucks. Smallville sucks. All these places suck, and they don't exist. Dunky's Donuts is the McDowell's of donuts. Oh, my God. Stephen Cooper, welcome to the super lawyer level. Much appreciated. Mr. Bentham says, Nick, I hate this moonshine. Also, Nick, I don't have any more moonshine. I finished the bottle yesterday. Look, you can make bad decisions. It's okay. Like having this next glass of Old Forester. By the way, we're at 937 likes. I'm going to drink this, assuming you guys will get me to 1,000 likes. Please don't make me wrong. Phoenix Lord Asserman, most of the time, small-town family bakeries do not make the best donuts. I don't need to change your mind when it's wrong. The Gray One says, good evening, Nick. Hope you've been well. While listening to this, I am, dare I say, cautiously optimistic for Vic. Fingers crossed with a comfort in hand. I am too, man. I don't know what to feel. It's wiggling, and I don't know what to make of that. Gelth Walker says, Nick, stand on Chair Coon and win me a beer, would you? No, I'm not going to stand on Chair Coon. Sorry. I don't like beer, and so I'm not interested in helping you drink something bad. Alan Reese says, did Vic mention in court how he was feeling, though the lies and bullying he received, except for the depression medication? In court, I don't know what Vic mentioned at the one hearing he attended where he testified. At his deposition, he mentioned a lot of stuff. Jade O says, Phoenix Lord Asserman, what town is this? What town do I have to go to prove you wrong? Jade O says, I had a nun for a teacher in grade 6, and everyone hated her guts. One day she found a note calling her a bitch and matched it to my homework, which my mom used to do for me, and we never saw her again. Angry Vainling says, my internet was dead for 3 days, but it's working now, just in time to see that 10 out of 10 hair. Nikki, how have you been? Base lawyer, man. Vainling, I've been very, very good. 200 Watt Studio says, Nick, you are worse than Shitley's Donuts? You fucking what, mate? 200 Watt Studio says, what is your preferred order for the Ender series? Ender's Game, Ender's Shadow, then the Shadow series, and I don't care if you read the Ender series. That's my preferred order. But I'd read Shadow series first, and then I would read the Ender series. It's chronologically intact, but it's also, Bean is the better character than Ender, in my opinion. In my opinion, Bean is the better character. He is much more complex than Ender. And I like Ender just fine, but Bean is a better character. And I love Orson Scott Card's I like his political drama, and I think he nails it. And that is much more prevalent in the Bean books than the philosophical and slower approach that the Ender books take. You didn't like that movie. The Ender's Game movie was bad. Classical Positioning says, on the anime rant, I feel like you could just substitute suck with low quality. Food's a good example. Junk food has 0 nutrients, but it's tasty. Sure. Yeah. Ghetto TV says, hack the planet! Hashtag I am Crash Override. Yeah, buddy. Loreddit Silver member says, if the case goes through appeals, is there any plausible scenario where Ron's admission of coom eating tweet could be submitted with the other tweets? On the off chance that Ron is redeposed, I guess I could say, now, did you eat semen? Austin Heartless has sent you a DM on Discord. The EPA is up to some shady stuff revolving around motorsports. Doesn't surprise me at all. Diamond Duck, I'm not recommending the Ender's Game movie. I'm talking about the books. The books. The Ender's Game movie would have been much better. Like as a HBO, Showtime, Stars miniseries. It could have been really fucking good. And instead they made the movie. Oh God. 2 hours? 2 hours for Ender's Game? Should have easily been a 10 to 12 hour miniseries. Unaccompanied Sonata is his best work. King's Meat is a close second. Is that card you're talking about? Did you read that one called The Boys? I think it was. Maybe it wasn't The Boys. Lost Boys. It's called Lost Boys. Oh my God, that was brutal. Not Lost Boys, the vampire movie with Kiefer Sutherland, which I love. Not that, but the Orson Scott Card short story Lost Boys was fucking heartrending. Ugh. Angry Baneling says, Risk of Rain 2 again? Look, I want to finish the game I'm already well into. That's all. That's all I want to do. Brutal good or brutal bad? No, it was brutal, like heartrending. It was off. It was hard to read, man. This is a sad, sad book. Risk of Rain 2 again. Why you do this? How about you start Dark Souls 3 for your next game? That sounds terrible. I'm not the biggest fan of the Souls games. I know you're like gay for them, but God, they're not really fun. You can skip 2. It's shit. Also update your video description, please. Eventually. I'm not worried about it. Terrell Navarro says, did you see Wolf Warrior refuting Emmett's claim of you committing a crime? Yeah, we covered it last night. And Catherine 2-Ton suggesting he's using the threat of a slap against anyone who contacts the convention about him. Yeah. I did. Good on them for being consistent. Angry Baneling says, India makes great spicy donuts, though. Look up Vada. I will not. It's not real anyway. You can't get it. Geld Walker says, okay, now it's been upgraded to a bottle of scotch. Now dance to my paying tune, monkey. Get up on that chair. I'm not going to get up on the chair. That's weird. Jackson Kai says, if one Warhammer 40K book could get a movie with Marvel-level funding, What book would you pick? I don't know how you do that. I don't know how you would do that at all. There is no single Warhammer book that is a standalone, standout piece. I'm looking though. Yeah, I have literally no idea. I have no idea how you could do it. It's got to be the Heresy books. There are 50 of them. You can't start with Horus Rising and be like, "Oh, this will be great." It doesn't make sense. Valador is actually what I was thinking, Phoenix Lord Asserman. Valador is there's a lot of cool shit in that. Wait, no, Valador. No, I'm thinking Constantine Valdor. Not Valador. Oh, the Rin's World would be a good book. Good book to put into a Marvel movie. Rin's World, the Space Marines Battles books. Here, this. If you've got one book to do, this one might do it. This is Cantor Prado on the cover here. This is the Crimson Fist chapter when their homeworld gets attacked by orcs, and one of their defense missiles hits their fortress and kills like 90% of the Crimson Fists. And then, the like 10% of the Legion that's left has to fight off an entire orc invasion on their home planet. It's brutal. It's heavy, fast-paced. It's cool. That would be a good book, or a good book to movie. Anything with Robute, fight me. The Calth, Betrayal at Calth would be a good book to put into a movie if you're going to do that. But that's jumping into the middle of the story is a little weird for me. Okay, next. Loreddit Silver member says, another plus, since the new donut shop is only 2 hours away, Nick will be able to wake up and smell them every morning. you brutal bastard. 200 Watt Studios says, agree on the Ender movie. Liked it, but it was Cliff Notes. Agree it should be limited series. Loved Ender's Game book, but couldn't get through Speaker. Yeah, the Ender books, I think they get way too philosophical. And I like them, but I like them on a way different level. The Bean books are visceral, immediate, identifiable political thrillers, and they're good. They're really fun and engaging. So I would read Ender's Game, then I would read Ender's Shadow, and the Shadow series, because they're actually fun. Hell's Reach, I think that's another that's a Space Marines Battles book. That's a good one. I would love to, they're supposed to be doing an Eisenhorn miniseries. I think that would be awesome. Or Amazon Eisenhorn series. I think they could do it awesome. I don't know that they will. I don't know if it's still in the works or not. Angry Baneling says, best Warhammer movie to make is StarCraft. Facts. Well, yeah, because StarCraft is literally a Warhammer ripoff. You know that, right, Baneling? Like, you understand that Blizzard was supposed to be making a Warhammer movie, but they screwed up the IP too much, and so Games Workshop pulled the license, and so they put out a bastardized stepchild called StarCraft. I hope you understand that. Okay, next. Bad Dragonite says, so basically what you said earlier is that Krispy Kreme is the anime and game storytelling of donuts. Yeah, kind of. Marty Lund says, because to believe a source obviously dubious, think citing to something called Pretty Ugly Little Liars, a blog with a public disclaimer against the veracity of its content, or a person who make a proven false rape accusation might be a tiny bit dubious. Yeah, absolutely. Absolutely. Night of Hope says, yeah, all my retard lefty coworkers are openly rooting for Texas to fail because they hate us that much. We're actually enemies with these stupid people who are living around us. Never thought my country would be this much of a shithole in my lifetime. Wolfgang Deo says, please show me Bob's and Vagine or face Boomer Ann and a death squad of marsupials with pouches for their young Karen Rudes. Night of Hopex says, I wrote some coverage of anime that I sent to you and then ended up deleting it, as I do most posts on social media, because someone I know got offended about their sacred cow and whined at me about it. Well, yeah. Did you not know that when I say that anime storytelling is bad? People whine at me all the time because it's their sacred cow. And they're like, no, it can't be bad. I like it. You can like it all day. Fucking waste of time discussing anything seems like. Yes, of course it is. It's terrible. You can't discuss anything because everything's a sacred cow to somebody. All right, guys. There we go for the stream. For the stream, we are good. Thank you all for joining me. Thursday, we will have Az Heel versus Babyface on for a painting stream. I can't wait for that. Friday, I believe I will probably be on Eric Hunley's show. So that'll be fun. I will see you guys on Twitch. I'm going to finish my Risk of Rain run, and then we will watch the whole 9 yards. It should be fun as well. Colin S. Yeah, you're from Apple Valley? Where in Apple Valley? How old are you? I'm from Lakeville. We probably know people. We probably know people who know each other, at least. Bad Dragonite says, Horus Heresy books condensed to a trilogy could be good. Nope. Horus Rising was my first 40K book, and that intro with the False Emperor was great. Yeah, it really was great. But there's no way you could do the Horus Heresy books as a trilogy. They were going to. It was going to be a trilogy of books, and then they made it 50. They can't do it. All right, guys. Thanks for hanging out tonight. We'll see you tomorrow or over on Twitch. Have a good night. Peace. Peace. Oh, damn it. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plenty folks, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're So pour out an Ardbeg, a Balmore, a Lafroig. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Planning tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed to make the law what we have